It is May 25th of 2026, and this is the Court Gallery. Today from the gallery, we begin with a few selections from last week on this special Memorial Day presentation. A woman sues an international car company over a supposed brake defect, but the judge is curious how she left the scene of the accident with bad brakes. Then, a man a judge knows from drug court shows up on new charges of attempted strangulation. Now he's facing life behind bars, and the judge is setting bond accordingly. Finally, we'll see first appearances from today, and you will not believe the 911 call a 70-year-old man made after a marital dispute turned nearly fatal. It's a special Memorial Day episode from the gallery, and it all starts right now.
Hi, Judge Middleton calling. We had a power blink over here, but I think we're back up. Could I see Vance Long in my courtroom? All right, thanks. Bye. Good afternoon, Mr. Stickley.
Good afternoon, Judge.
All right, I tried to squeeze this matter in at 2:45. I've got some landlords or some small claims cases that start in just a couple minutes. We and afternoon. This is a violation of a no contact order of a bond condition. The person he was not supposed to have contact with slapped him allegedly, and she got arrested. He is represented by Attorney Ross Truckee and is set for a last pretrial for June 11th. Are you Vance Long?
Yes, sir.
This is Judge Middleton. I'm here at the courthouse. I've got this weird, funky background thing here because the state is conducting a satisfaction survey, but I think maybe you can see me on the other feed. You got arrested last night for violation of a no contact order on your bond. With us, you can see him on the screen as Mr. Keith Stickley. He's the chief public defender for St. Joseph County. You were alleged to have assaulted Arlie James, your girlfriend, and that was alleged to have occurred on May 13th of 2026. You pled not guilty to that April 13th. There was a final attorney pretrial. You continued your plea of not guilty. The matter is set for an attorney pretrial with your lawyer, Mr. Ross Truckee, for June 11th. I'm going to put you in the waiting room while you wait for your small claims case. That ceiling fan's kind of driving me nuts. She's chomping away on the gum. We'll set her aside for a minute. Anyway, she got arrested for assaulting you, and she's in jail, and you got arrested because you weren't supposed to be there in the first place. So the question I have to decide is, am I just going to leave you in jail until June 11th? I'm going to let you out on some sort of a bond. Are you employed somewhere?
Yes, sir, I am employed.
Where's that?
It's at Precision Wire, sir.
When did you start there?
I started there. I got released from here actually, first time. So I think that was April 13th. I'm not terribly sure.
Laura, would you confirm that he's employed at Precision Wire? Where do you live?
I live at 218 North Lincoln Avenue, Three Rivers, Michigan. With my father.
Where does she live?
She lives at, I believe, 1228 Hav Air Drive, and that's with her mother.
All right.
Yes, sir. Yes.
Someone called the police while you guys were in the TSC parking lot, said you were fighting inside the car. Then you
Yes,
took
sir.
the fight to Wendy's drive-through and the cops got there and it was still not going very well. What?
Allegedly.
Allegedly. So it was a clear instruction that you weren't to have any contact with her. So
Yes, sir.
how do I know if I let you out of jail, you're not going to continue to blatantly violate the court's order?
Well, that's because I want nothing to do with any trouble. I want to, as I said, I'm going to get my life on track. And the reasoning that I was with her in the first place.
But don't tell me
don't
about
get into
that.
that stuff.
Laura, I don't know if you heard me. I hope you did. Anyway, you weren't supposed to be, and it violates your bond. So I could cancel your bond and leave you in jail. I have to give you a bond within 28 days. You have a hearing set for June 11th.
Yes,
And
sir. I would greatly appreciate it. Do not leave me in here. And I would do everything right. It was just a misunderstanding at that time. Yes, sir.
well, there was, all right, let's get clear. You're not to have any contact with her. Now,
Yes.
she's
I
charged with
understand.
assaulting you. So she
Yes, sir.
also has an order not to have any contact with you. If you're telling
sir.
me the truth about working at Precision Wire, I'm gonna give you a, what shift are you on?
Second shift, sir. I am scheduled today at 3 p.m. to, I believe, 11:30 or 12:30 p.m. And I'm working. I got moved to seat frames.
All right, I'm gonna reinstate your bond. I'm gonna set a bond violation hearing
Yes, sir.
for June 11th
Yes, sir.
at 2:00 with your last pretrial.
Yes, sir.
That's a contempt of court, even if you're found not guilty of the principal charge, you could be found guilty of contempt for violating the order for no contact. Anyway, I'm gonna let you out of the jail with explicit instructions: no drugs, no alcohol, no threatening behavior, and no contact with the complaining witness, who is Allie James. You understand?
Sir. Yes, sir. I fully understand. I fully understand.
All right. You're good to go. Thank you, Mr. Stickley. All right, so let me remove the jail. So we will take up Brandy Carson versus Stellantis Motors. The file number is 26682SC. Ms. Carson has filed a small claims action requesting $6,244. This is typically not the kind of case that we filed in small claims court. As a result of a defect in Stellantis Corporation's vehicle brakes, I almost lost my life and suffered damages by losing my vehicle, work opportunities. I had to close my shop due to financial issues as a result. Mr. Jason Bentley is here on behalf of Stellantis. Mr. Bentley, what's your position with Stellantis?
Your Honor, our position is that this is not a manufacturer's defect. This is more than likely an issue that needs to be taken up with their insurance company based on her request for.
What is the CRM?
Oh, that's customer relations manager.
All right.
So my position at the company.
Is this the type of case Stellantis is going to move from the small claims court to the general division of the court?
To be honest, I have been discussing with our legal team. We were kind of surprised to see this being taken up in the small claims court as well. At the end of the day, I guess it's up to Brandy Carson on the outcome of this and what she wants to do.
All right. Well,
and our stance is,
surprised.
yeah.
I don't choose which cases are filed here. You're about to go to trial on a claim for $6,000. You're not an attorney. You don't have to be an attorney in small claims court. You have a position that's not a manufacturer's defect. You have no expert witness. She's going to testify, and she's got a witness here to testify. And you run the risk of having a $6,000 judgment against you. All you got is you and hearsay. I don't select the cases that are filed. They get filed. It was served. You've accepted service, and you're here. She's prepared to provide evidence and testimony in support of her claim. You got you who says, hey, we don't believe this is a manufacturer's defect. Your legal team didn't say they were going to remove this. They were just going to leave it as a small claims case.
Unfortunately, it was sent through our call center. It's sent to me, and I received it about a week ago. So I was kind of surprised as well, but I figured it's still
all right. Well, let's table that case for a minute. We had about 6 cases scheduled today, and the translator cases take a long time, but we've worked through 5 of them. And what's left is entitled Brandy Carson versus Stellantis Motors. Mr. Bailey, would you rejoin us, please?
Your Honor, am I okay to leave?
Yes.
Thank you.
Ms. Suter, thank you. All right. Would you each please raise your right hand? Angie, if you're going to testify in this, I'm going to ask you to raise yours as well. But at this point, Joe, please raise your right hand. You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
Swear.
I do.
All right. Ms. Carson owns a business called Colorful Roots. And she sued Stellantis as a result of an automobile accident. This is small claims court. It's not general civil court. And there are certain things you can sue for and certain things that you can't. You can sue for money damages for damage to your car. You can't sue for a tort like intentional infliction of emotional distress or some of those things. In your claim, it's quite brief, but you've attached a lot to it. I'll read it. As a result of a defect in Stellantis Corporation's vehicle's brakes malfunctioning, I almost lost my life and suffered damages by losing my vehicle, work opportunities, had to close my shop due to financial issues as a result. I'm asking the debt be cleared to be reimbursed, I guess it is. So, Ms. Carson, how did you come up with this figure of 6,244?
Yes, so the figure that I have is actually higher than that, considering that my insurance premiums went up from $200 a month to over $500 a month as a result of the accident. So that total amount is actually $3,806.42. The
All right,
5,000.
give me that. All right, stop. That amount, give it to me again, 3,000.
Yes, sir. It's $3,806.42.
And that is for your increased insurance rates?
Yes, it went from $207, which I have the documents there, to over $500 a month as a result of this accident. That was not my fault.
All right, there's 3,806 of the claim. What is the rest of it?
So the $5,000 is a $5,000 deposit that I put down on the vehicle to purchase the vehicle. I had the vehicle less than 2 years, and I no longer have the vehicle due to the brake defect, where I had no control over my vehicle other than to steer it, and that's how I ended up crashing into the tree at the base of River Road, headed towards downtown Three Rivers. The $1,244 is the cost that I spent to get rentals in order to still try to maintain business. I had a shop that I opened in 2016, downtown Three Rivers, that I ended up having to close because I needed to make financial decisions to stay afloat. And I do have the document, I think you have it included, where it does show the insurance deemed the accident not my fault. It was a mechanical technical issue that happened with the vehicle where the brakes were frozen and
All
I
right,
could not.
refer me to that. You filed
Yeah.
pleadings that are very small print and I can't read them.
Yep, I've got this. You should have is the letter from auto owners insurance, stating that the accident was not my fault.
All right. Please be advised that the above referenced claim involving a 2020 Jeep Grand Cherokee on April 6, 2025 was deemed a not at fault accident. Should you need additional information, please contact. So not at fault is different than saying there was a defect with the brakes.
Yes, Your Honor. I had a mechanic inspect my vehicle and it was deemed a defect. Also, I included information.
Stop.
Sorry.
Where is that?
I think I have the check showing where I paid for that. And it wasn't, Your Honor, it wasn't just an accident. I hit the tree and the vehicle actually continues to accelerate afterwards. That's the nature of the defect. So the vehicle kept going even after hitting the tree.
All right, but where is your expert that says this was a result of a defect with the vehicle?
I have the check. I was not able to get him to come here, but I have the check there showing that I paid him to inspect the vehicle.
All right, well, who is that?
It's the cancel check, not cancel check, but the check should be there. I also included statements from other people that own a Jeep that have the same exact experience. And I have the pictures showing how the vehicle worked itself out of the dirt and kept going.
All right, well, you're claiming this was a result of a defect from Stellantis Motors. This car is 5 or 6 years old at the time of this accident. You had owned it for 2 years. I can't tell yet how many miles were on it or what the service record of it was. But you have to establish that there was a defective product. Usually this isn't done in a small claims case. You gotta do more than throw spaghetti at the wall and hope it will stick. So who is your expert to say that this accident was a result of the brake defect?
The insurance company did the inspection, and that's how they discovered that
All
it
right,
was
well,
not
where is that?
I have a separate case with them. They did not supply me with the actual detail of the information, but they said that they agreed that it was not my fault.
So you also have a separate claim against the insurance company?
Yes. And if you look at the pictures, you can see where the vehicle impacted the tree, and then you can see how it kept going. And then if you look at what I included from testimonies of people that had the same exact situation happen, all that should be in there.
I'm familiar with this intersection. Drive it frequently. It is a sharp curve to the left. River Road comes in. At one time, there was a bridge there, the Wood Street Bridge. You weren't born yet, but you could cross in front of the dam to Wood Street. And that would take you from Second Ward into Fourth Ward. I can see that you apparently went through the grass at the plant for quite a distance. There's a dam there, which is run as a hydroelectric dam.
Yeah. Your Honor, the vehicle just kept going. The only way I was able to stop the vehicle was to force it into park. Had I not been able to force it into park, I would have ended up in the St. Joe River.
All right, well, so that may not be a brake defect, it may be a throttle defect.
Well, the gentleman that I had look at my vehicle, he looked at it and he said it was a computer issue. I also went back and forth in communication, which I do have documents of that with the insurance company where they questioned the brakes, and I showed proof, which I have included in there, that the brakes were checked. So there was nothing wrong with the brakes. I literally could not, the brakes were frozen. Usually you can push down the pedal in order to brake. It was frozen, totally deactivated. After that situation, I looked to see if I could find recalls, and I came from situation after situation after situation where the same incident happened with several people with their Jeeps, where the brakes were deactivated and some of them crashed into the lake in one incident. Another person crashed.
All right, well, that's all hearsay. So now I also have auto owners, and then I also see Progressive. That's when your insurance went up. Is that correct?
Yes, my insurance premium went up as a result.
What's your lawsuit against auto owners?
Well, really, I would like to just get things settled with Stellantis because I talked to them earlier today. They said that the reason why my insurance said that it was the reason why it was listed or reported as me being at fault was because Stellantis listed me as fault and not them. So That's why my insurance went up.
All right. At 8 o'clock in the morning on April 7th of 2025, they were dispatched to 401 8th Street for a dam employee requesting that the vehicle be removed from the property. It's not clear what time the accident took place. I arrived on the scene and the caller, Clements, had left. He explained the vehicle had been sitting on the grass and he would like to have it removed. I advised Clements the vehicle could be removed. It was on private property. He assured me the vehicle was on the hydro dam property. He additionally returned to the scene to sign authorization to remove the vehicle. I made contact with Brandy Carson, who was aware her vehicle was on the property. When Carson stated she was driving the car the night prior, so sometime previous evening is when the accident happened. Carson stated she had walked home and planned on having the vehicle towed in the morning. That's called leaving the scene of a property damage accident, is what that's called. I informed Carson that due to the vehicle being on the hydro dam's private property, they requested it be towed. Carson was advised the vehicle will be towed to the Shears lot. So you got in an accident sometime that night. You walked home. You didn't call the police. The dam owner called the police to get your car towed out of there, and then the police called you. That is a misdemeanor offense of leaving the scene of a property damage accident. They didn't cite you for that, but and now you claim that it's Stellantis's product defect, but you don't have any expert to tell me what it is. Mr. Bentley, what's your position?
Our position is that this is not a defect, that this was either user error or lack of maintenance, where items like brakes are 12-month, 12,000 mile warranty, basic warranty 336, all that has been expired. Owners of the vehicle are responsible for maintenance. So if there was actually an issue with the vehicle, it's not covered under a warranty anymore. But there's been no proof that there was an issue with the vehicle, and the fact that the vehicle was abandoned, very limited information based on just check, no actual inspection, that this is not an issue that should be represented by Stellantis, and this is an issue with the insurance company or something that or their lack thereof in terms of gap insurance and all that.
You don't have any better expert than she does. You got this crappy assignment from your boss says, hey, show up in court in Centerville and defend this small claims action. The one thing
I
you
do
did
have a
say,
strong background in
yes,
automotive mechanical, so I do know how
the vehicle was not under warranty. And I don't know how many miles it had on it. I saw something that seemed to say 80.
Your Honor, I did have an extended warranty on the vehicle, but the brakes were deactivated on the vehicle. I put my right hand up. I see several other people have had the same issue, and it is a shame that Stellantis will not take responsibility. I'm sure there's plenty of other people that have.
Well, there may be a better way to do this with proper counsel and proper expert testimony, but this is a small claims case. And you're unrepresented. You don't have an expert. He doesn't have an expert. And you left the scene of the accident and can come back for hours later, which convinces me enough not to grant judgment on your behalf. I don't know whether these brakes were defective or not. I don't think it's brakes. I think it's some sort of computer issue.
It was a computer issue, yes. Yeah.
All right. So it's not under warranty at that point. You have to prove that. All right. Well, if it's under extended warranty, then sue the warranty company. But you're trying to establish in a small claims case with hearsay evidence and an expert who won't come in and testify that this is a defective product and you haven't met your burden. And you left the scene and
I
didn't
did
come
not have
back for,
it was nighttime and I did not have my phone on me and I live right on the same road. I was absolutely freaked out because can you imagine driving a car and all of a sudden your brakes have no control over the vehicle but to steer? In any normal accident, if you look at the pictures you see, hit a tree, that vehicle would just stop. This vehicle did not work itself.
all right, I can't tell what it is. I can't tell if a brake line leaked all the brake fluid out. I can't tell whether it was a computer chip that went out. I can't tell whether it was operator error. You were driving too fast around that curve. The speed limit there, I believe, is 25 miles an hour. I don't have any estimate of how fast you were going, but your car did go a long way. And so, anyway, I find you haven't met your burden of proof. They sent Mr. Bentley out here to represent the company. You can sue him with a lawyer for a product defect, but now you filed this case, which might make it res judicata, meaning you can't bring the case twice. But I find for the defendant, the damages are zero. I find the plaintiff has not established beyond the preponderance of evidence standard that this was a matter of a product defect. Other cases are hearsay. There's no inspection. There's nobody that tells me this is what I inspected and this is what it was. There's some hearsay about maybe it was a computer chip, and you left the scene for hours, 12 hours or more. I don't know what time this happened, if it happened at 8 a.m. or 2 a.m. At any rate,
8 p.m.
All right. Well, there was plenty of time to call the police, and that didn't happen. All right, this case is dismissed, and I find zero for the defendant, or zero for the plaintiff, and Stellantis not ordered to pay anything. Miss Carson, are you still at the South River Road address?
I am.
All right, you're all free to go.
Thank you, Your Honor.
All right, that was a very busy afternoon, and that was a very strange case. But even in small claims court, you need to establish some sort of evidence. And I didn't find it here. That's the kind of thing that involves hyper-technical testimony and perhaps class action for product design, but I didn't find it in this case.
All right, the court will call the matter of the State of Michigan versus Timothy Wadesky, file 26-44590-FY. Mr. Wadesky is with us. Mr. Wadesky, I'm here to give you, to do an arraignment for you. I'm going to tell you what you're charged with, tell you what your rights are, and then we're going to set bond. With me today is Mr. Fortier from the prosecutor's office and Mr. Brown as defense counsel. The complaint against you reads as follows. It says that you did on or about May 11th, 2026 in City of Gaylord, Otsego County, that you did commit the offense of attempted assault, bodily harm, less than murder, / strangulation, in that you did attempt to commit the following listed offense, and in the attempt did an act towards the commission of that offense, but failed in the perpetration or were prevented in the execution. That is that you did make an assault upon Andrew Christopher Goebel by strangulation or suffocation, contrary to the Michigan compiled laws. That is a felony offense. Mr. Fortier, help me out with the possible penalty here. This says that if the offense attempted was punishable by life for 10 years or more, it's a felony offense. I assume that the assault GBH is a 10-year offense, right?
Yes. Which then makes it under
So
the
this
attempt
makes it a
statute,
5-year
makes it a
offense. All right.
5-year
So the
felony.
maximum penalty, Mr. Wadesky, for this offense is 5 years and it requires DNA identification profiling. In addition to that, you are charged with being a habitual offender, fourth offense, which says that you were previously convicted of 3 or more felonies or attempts to commit felonies. In that on or about April the 18th of 2024, you were convicted of the offense of attempted resisting and obstructing a police officer in Otsego County District Court. On or about January the 9th of 2025, you were convicted of the offense of resisting and obstructing a police officer in the 46th Circuit Court for Otsego County in the state of Michigan. And on or about January 9th, 2025, you were convicted of the offense of resisting and obstructing a police officer in violation, in the 46th Circuit Court for Otsego County in the state of Michigan. Therefore, because the underlying offense as a penalty of 5 years or more, this penalty is now up to life imprisonment. So you are charged with the offense of attempted assault with intent to do great bodily harm or strangulation. That has itself would have a penalty of 5 years. But because with the habitual offender on it, it becomes a life felony because the underlying offense has a penalty of 5 years or more. Do you understand the name of the charge that's been made against you?
Yes, Your Honor.
Do you understand the maximum possible penalty?
Yes, Your Honor.
Right now, you have certain rights. So I'm going to go through them with you to make sure that you understand them. You have the right to plead guilty, not guilty, or to stand mute. You have the right to be represented by an attorney. If you want to retain your own attorney, you can do that, or you can ask for a court-appointed attorney, or you can represent yourself. You also have the right to have a trial by a judge or by a jury. If you wish to have a trial, you'd have the right to see, hear, and question all the witnesses against you. You'd have the right to ask for the court or to get from the court a subpoena to require your witnesses to appear and testify. At a trial, you could testify or you could choose to remain silent. And if you chose to remain silent, that silence could not be used against you. At a trial, you'd be presumed innocent until proven guilty beyond a reasonable doubt. That burden of proof would remain with the prosecutor at all times. Finally, at a trial, you'd have the right to automatically appeal any error at that trial. But if you enter a plea in the future, you'd be limited to asking the court for permission to appeal. Do you understand the rights that I've just given to you?
Yes, Your Honor.
Do you have any questions about any of those rights?
No, Your Honor.
Mr. Brown, have you met with Mr. Wadesky as to his right to an attorney?
Unfortunately, I have not, Your Honor. I got this rather late. When I called over to the jail, they were taking care of other matters. He has
All
been
right.
represented in the past by court-appointed attorneys. I do know that.
All right. And I'm familiar with Mr. Wadesky's current or recent issues. Mr. Wadesky, would you like a court-appointed attorney?
Yes, Your Honor.
All right. I believe that he would qualify for that. I'm going to ask Mr. Brown to get with the Mr. Gilo's office and make sure that that's true. But for now, I will appoint court-appointed counsel. Mr. Wadesky, because you've asked for an attorney and you have not had a chance to meet with that attorney yet, I'm going to enter a not guilty plea on your behalf in order to protect your rights. I'm also going to set a probable cause conference and a preliminary examination. Those are 2 court hearings that are also going to protect your rights. The first one is a chance for your lawyer and the prosecutor to meet and try to resolve the case quickly. That'll happen within the next 7 days. The preliminary examination is a requirement within 21 days. That's where the prosecutor has to come into court and bring evidence that amounts to probable cause that the crime that you've been charged with was committed by you. So we'll have those hearings set as quickly as possible to protect your rights. What we're going to do now, Mr. Wadesky, is turn to the issue of bond, and I'm going to hear from both of the lawyers on that issue. And then if you wish to make a statement as to bond, I'll hear from you as well. Mr. Fortier, your thoughts on bond?
Judge, I think the court is already somewhat familiar with the circumstances that led to Mr. Wadesky's hospitalization originally. This case kind of stems from that hospitalization. I think when you look at the totality of the circumstances, he presents not only a danger to himself just with his, the issues that he's got going on in his life, but I think also obviously a danger to the community at large, constantly fighting with police officers, now he's fighting with the security staff at the hospital. I think it's pretty clear that he presents a pretty significant danger with his anger issues. My understanding is also that at this point, Mr. Wiedeski doesn't have a stable living environment. So I think that should be something that the court should take into consideration. Any bond that gets set would also have to be cash surety only because he has the prior convictions for felonies within the last 5 years. He's also currently on drug court probation, as the court's well aware, out of case 25-6791-FH. So I would ask that the court order the standard terms and conditions, no drugs, no alcohol, no marijuana, that he continue, if he does bond out, that he continue with his treatment programs that he's engaged in with Bear River or any sort of additional treatment programs that he's got as a result of his recent inpatient stay, that he report via community corrections. And I would leave the issue, the amount of bond up to the court. However, I would ask that the court consider an elevated level or an elevated amount of bond, just kind of based on his prior history and the facts that led up to this.
Thank you. Mr. Brown, your comments?
Your Honor, it sounds like the court is familiar with Mr. Wiedeski. The only issue that I would have that I would like to bring up is if he is in any kind of treatment, in any kind of programs, I would want to make sure that he continues those. As far as any bond amount, given the court's familiarity, I would leave that at Your Honor's discretion.
Thank you. Mr. Wiedeski, I'm going to give you an opportunity to say anything that you would like me to hear at this point. I would caution you about not making any statements about the underlying facts of the charge that's been made against you, because we are recording this and I don't want that to be used against you in the future. But if there's anything else that you'd like to tell me about your living situation, about your mental health, about your ability to stay out of trouble, I'd be happy to hear those things, sir.
Yes, Your Honor. First and foremost, I want to say I'm super sorry about what happened.
Mr. Wiedeski, you don't want to get into the facts of the case or say something.
I wasn't going to go there.
Well,
I just
he's
wanted
trying
to
to
say
say
that
that he doesn't. Hang on just a second. He's trying to say that if you try to apologize, that may be an admission of guilt. And so I understand. I understand that you feel bad about the circumstances, and I've known you through drug court for a long time now, so I can assume that. So you don't need to tell me that. And again, I'm just trying to do that to protect your criminal case. So if there's anything specific or factual that you want to let me know, that's what I'd like to hear now.
Yes. So I just got out of the treatment facility today with a great plan. I have doctor appointments lined up. I got put on new medications to help to keep me very, very stable. They kept me at the facility for a long time, longer than I've stayed at a facility ever before. I understand that Mr. Fortier would like an elevated amount of money for me to pay for bond, but if you could at all maybe think I'm going to need that money to sustain living so I can continue being stable. I would like to maybe seeing Luke Hamlin 5 times a week just to check in more. So you guys can see me more frequently. If you would like me to go to counseling with Rosario 2 times a week as well, I'm willing to. I think I need that help, at this moment in my life. And I think that Bear River, as they have a peer recovery coach, her name's Kathy McGathy. I know that sounds like a weird name. I'm not making it up, but that is her name. And she's very, very, very good at helping in certain situations like this, that I think could be a great advocate for me, and that helped me get on the right track. This morning the plan was for me to go to the refuge so I could have a stable place for at least a couple weeks. So NIMSCA and my parents, and we're all trying to figure out how to give myself a stable living situation. But me in here right now, I'm unable to do that. But I came out of the hospital today with a great plan, and I was picking up my car and I was going straight to the refuge. I had a whole plan ready today. I called Luke right on the way home just to check in. I was supposed to have a meeting with him at 1 o'clock. Unfortunately, I missed that. I believe he informed the police officer I was picking up my vehicle, but I do have a plan, sir, and I'm not trying to be a danger to society. I'm not going to get into it because you told me not to, but the circumstances that happened at the hospital, that they're out of my control. That I was not just walking around Walmart looking for somebody to strangle. Like, I had a ventilator down my throat.
I understand those things. And again, I want to be careful to not have you talk about the facts of this particular case, because I don't want it to be used against you later. So I understand what you're telling me, that there was in your mind a reason to do what you did, and I'll leave it at that. All right. Yep. Anything else any other facts that you want me to be aware of, sir?
No, I just appreciate you all seeing me in a very timely manner today.
All right. Thank you, Mr. Wadesky. Mr. Wadesky, go ahead.
Sorry, I was just going to suggest one more thing. Mr. Wadesky kind of hinted at it. I think with us all knowing his history, if he does bond out, today, over the weekend, whatever, I would ask that he meet with Mr. Hamlin as soon as possible.
I'd go there right here. I'd go right now.
Might be good for him too if he checks in with Rosaria like right away upon any discharge from the jail as well.
And I'd make a phone call to her on the walk to Luke. My car's at the hospital, so I would be walking that way to Luke. Right now, I can make that phone call to Rosario as soon as I get out of here.
Thank you, Mr. Wadesky. All right. The court has alluded to the fact that Mr. Wadesky and I are acquainted through a drug court. Mr. Wadesky, I believe, is your phase 3 in that drug court program. Mr. Wadesky, is that correct?
Yes, Your Honor. I'm looking.
So you've been in drug court for about a year and a half now, give or take a little bit.
Since November 22nd of 24.
Yep. So, and I came on the bench in January of 25. So it's been almost a year and a half that we've had regular contact every couple of weeks during drug court. I've talked to Mr. Hamlin repeatedly about Mr. Wadesky and some of the difficulties that he's had to go through. I'm aware of his previous mental health concerns that came up during drug court, sobriety court, and required him to have some inpatient treatment a few months ago, much like his current inpatient treatment that he went through preceding these charges, or as a result of these charges. And so I'm very familiar with his history and his involvement in our local community from those things as well. I say that by way of making sure that everybody knows that I'm aware of his concerns and his issues. Mr. Wadesky in this particular case is charged with a very serious assaultive or attempt at an assaultive crime, and his habitual offender notice makes the likelihood of, if not long-term jail, likely of prison opportunity to go here. So these are very serious charges. His current living circumstance has changed. I'm aware of what that was through his sobriety court time, and he's not able to return to the house that he had been in as a result of that. So he would have to be in a something like the refuge, which would be a very temporary existence, and would not provide Mr. Wadesky with the structure in which he does best. In addition to that, Mr. Wadesky has had difficulties in the past taking his medications as prescribed and not abusing them, or taking them more on occasion and not taking them on occasion, which tends to make his moods and his circumstances go up and down somewhat, making it somewhat more difficult for him to be compliant with the requirements of law because of the amounts of chemicals within his system on occasion. And we've struggled with that with him over the course of his sobriety court experience. My concern at the moment not only is for the community, given his assaultive behavior as indicated in the complaint made against him, but because he's so recently out of treatment, and I believe that he needs to be in a very structured environment to make sure that the medications that he's on continue to be within him, and he thrives best in a very structured environment. And I don't believe he would have that available to him, even with the current assistance that he receives through the sobriety court. Mr. Hamlin cannot see Mr. Wiedeski but more than a few minutes each day. Ms. Rosaria, his counselor, can only be with him a few half hour or an hour on a weekly basis at best, and she's not readily available because she has other people that she deals with on an as needed basis. So upon discharge, if he were to be discharged into the community, I don't believe that he would be, I do believe that he would be a danger to himself and others given the lack of stability. All of that to say this, I believe that a high bond is necessary to make sure that the community is safe. And quite frankly, more importantly to me at the moment, is that Mr. Wiedeski himself would remain safe. He has been on suicide watch in the past, and I don't want him to have to return to that just because he was let out and left to his own devices at this time. So I'm going to set a bond in the amount of $50,000. That will be cash or surety only. He does not qualify for a lesser bond, given the fact that he's on probation with the sobriety court, and the fact that he has committed the felonies that were put on the record within the last couple of years, within the last 5 years anyway. And so he does not qualify for a lesser bond under those circumstances. If he does, or if he is able to post $50,000 cash or surety, he must personally appear for any scheduled court date, must abide by any judgment entered by this court. He may not leave the state of Michigan without the permission of the court. He may not commit any crime while on release. Must immediately notify the court in writing of any change of address or telephone number. May not use alcohol, marijuana, or illegal controlled substances, and may only use prescribed substances as prescribed. That means no overdosing. Must participate in a specified treatment program for any physical, mental condition, including substance abuse. That would include all requirements of the sobriety court. Any mental health requirements. May not have any contact with the victim. This is Andrew Goebel.
Judge, can we put somewhat of a qualifier on that? Mr. Goebel is a security officer at the hospital. So, I mean, in the event that Mr. Wiedeski has to go to the hospital, I think, any sort of like brief incidental contact between the two of them shouldn't be the main concern.
So I'll put down except as to employment requirements. So if Mr. Goebel has contact or sees him at the hospital, that's not a violation on Mr. Wiedeski's part. If he's going to the hospital for a proper reason, or is at the emergency room, that would not be a violation. However, if Mr. Wiedeski is not properly at the hospital, that would not be a proper employment reason for Mr. Goebel to have contact with him. There must be no assaultive, harassing, intimidating, beating, wounding, or threatening Mr. Goebel. So even if he is there appropriately at the hospital, there no further contact that way. No possession or purchase of a firearm or other dangerous weapon. Must contact community corrections. That's the agency that monitors people that are on bond for felony cases. The jail has the contact information for that upon any release. Mr. Fortier, would you ask for any other requirements of bond?
No, Your Honor. I think what's been put in place, along with the fact that he's still currently on drug court probation, are sufficient.
Mr. Brown, any input?
No, Your Honor, thank you.
Oh, I do want to add one more thing. If he is released, must meet with sobriety court probation officer Hamlin, counselor and that must be done within 8 hours of release and must follow all recommendations. All right, that's all for today then. Thank you very much.
Thank you.
Mr. Wadesky.
All right, this is the waive case of 18, Mr. McKenzie.
Okay. Anthony McKenzie is accused of 2 counts of battery family violence, case 26 CR 3335K from March 13th of last year. Mr. McKenzie's presence has been waived. Any priors on position 18, Ms. Harvey?
17. I'm so sorry. I believe he's also the add-on person too.
That's an add-on? Okay.
Yes, I apologize. We could not. Odyssey was not my friend today.
Okay, let me get into the add-on calendar. Mr. Geddes, were you aware of the add-on case?
I was not, Your Honor, but I do see that I was emailed it, so one moment.
There we are.
Yeah, I received it about 15, 20 minutes ago, it looks like.
All right. And is Anthony McKenzie aware that he has now 2 cases, or since you just found out 15 minutes long after you spoke to him, I'm assuming when you got his waiver?
Most of the charges that I see we had discussed, but the stalking charge is new to me.
So you even discussed the criminal trespass, simple battery, and willful obstruction from May 24th of 2026?
That was on the initial paperwork that I received. Yes, Your Honor.
Okay. You prepared to move forward with the stalking one as well?
I don't have any details on that one, but I don't think my argument will change because of it. So I think we're fine to move.
All right. And that new case number is 26 CR 00 3351K. So that new case is for stalking, family violence, criminal trespass, simple battery, and willful obstruction of a law enforcement officer. And this incident date is from yesterday, May 24th, 2026. So the first case is from more than a year ago, March 13th, and the second case is May 24th. Right? And I'm sorry, Ms. Harvey, any priors?
17 cycles. Last arrest was March 21st, 2024 for a probation violation out of Fulton County. There is an additional open case under 26 PI 004133 for aggravated assault, battery family violence, simple assault family violence, and possession of a firearm by a convicted felon. Appears to be on probation for trafficking controlled substance, sentenced in 2005 to 15 years confinement and 10 years on probation. 2024 disorderly conduct, and a 2004 simple battery and 04 criminal trespass. Recommendation is a level 2, nothing further.
Ms. Evans-Babb?
Yes, Your Honor, the court's had opportunity to read the warrants, and in the first one, the state is most concerned that the victim in this case ended up with having a swollen face and abrasions on her hands because she was punched, drug across the ground by the defendant, and that's our allegation, of course. This incident occurred at the address, and the victim in the case is Ashley Simmons. We are asking in this particular case, our bond recommendation is for we are asking for a cash bond. We're asking for a cash bond in both cases in light of the history of the open cases and certainly history of violence. $5,000 each charge for each battery in the first case. As to the second case, we did add the stalking charge because he laid in wait for the victim. He entered her house without her permission and had contact with her without permission. He hid underneath the bed. There were children in the home. It affected the safety of everyone that was present in that household for him to suddenly appear. And of course, there was an argument between the parties for him being in the home without permission. He apparently went to hit her or grab her, and as a result, he snatched her clothing off of her as a result of that incident. This also happened at the
Bolton Road location. And in both situations, it was where they had broken up. The first incidents, they had broken up. This is the second time. They hadn't been together since January. It's now May. And he committed this behavior. So for our bond recommendation as to the criminal trespass for $3,000, well, the stalking is first. We're asking for $5,000 on the stalking charge. As to the criminal trespass, $3,000. As to the simple battery, $3,000. And I think we had to dismiss the cruelty, but the law enforcement obstruction, $1,500. And that changes my calculations. I have $14,000 cash bond, but we need to subtract $1,500 from that. So that would be a $12,500 cash bond on the second case. No further contact with the victim, Ashley Simmons, no contact with any children that they share, any children in the household of her, stay away from the location, no alcohol, drugs, or weapons. He's already a felon. He's not supposed to have weapons or firearms. We'd ask that any firearms that he have be surrendered at this time. No, I did say no alcohol, drugs, and weapons, and that's our bond recommendation. Mr. Geddes?
Yes, thank you, Your Honor. So my client is a lifelong resident of Georgia, and he's lived here almost 50 years at this point. My understanding is that he resides out of the west side of Atlanta. He has an address there where he stays with his sister. She owns the property, is my understanding. As far as his employment, he owns a pressure washing company. He occasionally contracts employees to assist him with his work. He's had that company for the better part of 4 or 5 years at this point. He does have a GED, the high school diploma equivalent at this point. Judge, I would ask the court to consider the lowest possible bond. These are just allegations at this point.
Okay. On position 18, 2 counts of battery family violence, that's going to be $2,500 each. That's a cash bond only. No further contact with Ashley Simmons, to stay 200 yards away. No contact with any child or children that he shares with her. for no illegal drugs, no alcohol, no weapons. And he'll be required to be equipped with an ankle monitor, and it will be defendant funded. So he'll need to pay for the ankle monitoring, and this will be until further order of the court. With regards to the add-on case 26 CR 003351K, count 1 stalking is a $2,000 cash bond. Count 2 criminal trespass is a $2,000 cash bond. Count 3 simple battery is a $2,000 cash bond. And count 4 willful obstruction is a $1,000 cash bond. And that's going to be a $7,000 cash bond. Same conditions. No further contact with Ashley Simmons and her minor children. No contact, to stay away from wherever she lives. I've got a couple addresses over here in all 3 cases. So I'm going to go with the latest one, which is in Northwest Atlanta. No illegal drugs, no alcohol, no weapons. And again, ankle monitor concurrent to the previous case until further of the court, monitoring fees to be paid by the defendant. His next court date for both cases is going to be June 9th. And this will be in addition to his open felony case 26 PI 004133 involving the same victim. Thank you.
This got number 20, Mr. Smith. Hold on.
Joshua Smith is accused, Joshua Jeremiah Smith is accused of 2 counts of harassing communications and 1 count of terroristic threats and acts from May 10th of this year, case 26 CR 3346E. Mr. Smith, you've been advised of your rights. Your attorney is Mr. Geddes. Any priors, Ms. Harvey?
6 cycles. Last arrest was April 8th, 2023 out of Forsyth County for simple battery. And that case was dismissed, Your Honor. Recommendation is a UJR through the jail. Nothing further.
Thank you. Ms. Evans-Bell?
Yes, Your Honor. In Mr. Smith's case, I believe the court, in reading the warrant, see that there were several cases or several continuing conduct of Mr. Smith in communicating with the victim in this particular case. Yes, with the victim in this particular case, and we are asking for a bond in the amount of in this particular case, because of the nature and the amount of calls from the various different telephone numbers and the threat of harm that is recurring in the messages, the text messages that the officer was actually able to observe. And I suspect that once we get finished with these cases, it'll be more than the 3 charges that he has here. But at this particular time, we're asking for a cash bond. I think this is a significant enough of a case that we are actually asking for a $10,000 cash bond as to each count. We're asking that there be no further contact with Mr. Davis in this with is Kerrigan
Davis
in this particular case as well. That certainly I don't know whether or not he is aware of the address, but the address that's indicated is 402 Harbor Landing in Roswell, that he stay away from that location. And of course, that the court make sure that it's clear that what no contact looks like, in case he doesn't know what that is, that there be no alcohol, drugs, weapons, and that he possess no firearms because of the fact he's made specific enough threat in the text messages for this case. Thank you.
Is there a Kerrigan Davis or anyone here for Mr. Smith, other than Mr. Smith himself? I see a Tracy Smith. Is that courthouse staff or by coincidence?
That's me. That's his mother.
Did you want to address the court?
Yes, ma'am.
Then you need to start your video, please.
Yes, ma'am.
All right, Ms. Smith, good afternoon. My name is Judge Lall. If you'd like to say something, I'll need to place you under oath.
Yes, ma'am.
Raise your right hand, please. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Ms. Smith, do you know a Kerrigan Davis?
No, ma'am, I do not. Only through Joshua and what he has told.
All right. And what would you like to tell us today?
I'd like to start off with the accusations, if you will. My son does not know her only through social media. He's never been to her house. He doesn't know where she lives. And he's been harassed. Somebody pretending to be her and somebody's pretending to be him, and they've been harassing each other, if that makes sense.
No, it doesn't, but
okay, so somebody has been using untraceable phone numbers pretending to be Joshua to contact Kerrigan and vice versa.
Okay, I see. And you got this information independently or from Joshua himself?
Well, we have screenshots, we have messages. They've been trying to harass me. They've been trying to harass my husband for the sole fact my son has a mental illness, and they've been preying upon him off and on for 12 years now. Literally.
And what have you all done about it?
We've reported it, and they can't do anything about it because they're untraceable phone numbers.
Okay.
And so I would like to, we can't afford a lawyer. We would like to be able to present this info when, he comes back to court or when he goes to court. So we can't afford, much money to get him out, nor does he have any money to get himself out as well. So, but we would like to be able to prove all these wrong accusations against him.
Okay, thank you. Mr. Geddes?
Yes, thank you, Judge. My client has lived in Georgia since he was a child. My understanding is he currently resides in the address based out of Cumming, Georgia with his parents. I'm under the impression that it's his mother's address. She's on the line, obviously, here in support of him. Prior to him being arrested, I'm under the impression he was working 2 jobs, one at Qdoba, one at Publix, which he believes he may have lost those jobs as part of his arrest. So obviously, his financial status and his ability to pay any kind of monetary bond is uncertain at this point. He does have a high school diploma. I would just ask the court to consider either a signature bond or the lowest possible bond given the circumstances. As you've heard, my understanding is that he did not have any prior contact, never been to her address before. I've already talked to him about the stay away. He has no issue having no further contact going forward.
Okay. On count 1, harassing communications, that's going to be a $3,000 surety bond. On count 2 is going to be a $3,500 signature bond through pretrial services level 3. Count 3 is going to be a $3,500 signature bond through pretrial services level 3. This is going to be a total of a $10,000 split bond, which means that Mr. Smith, you've got a split bond where you'll need to pay on a portion of it, and the rest of it you'll be on a signature bond where you report to pretrial services once a week. So bonding companies charge between 10 to 15%. So you would have to put up at least $300 for the surety bond portion. And then the remainder portion, which is the $7,000, that's going to be a signature bond. You won't have to pay for the bond today, but you will have to comply with the following conditions. The conditions are that you report to pretrial services once a week for a period of 12 months. You are to have no further contact with Kerrigan Davis or any of her family members. You're not to communicate with her in person, through mail, through emails, through phone, through any kind of phone device, through any kind of computer device, and definitely not on social media. You're not to have any devices that indicate that you've attempted or tried to contact her through any of them, and you can't try to contact her through a third party. You are to stay away from, was it the Harbor Landing location, which is 402 Harbor Landing in Roswell, Georgia? You're to stay 500 yards away. Mr. Smith, this is a type of charge that can easily be construed as a felony matter as well. And given more reasons, I can impose an ankle monitor upon you. At the present time, I'm not going to do so, but don't give us any reasons to require an ankle monitor in the future. Do you understand?
Yes, ma'am. Am I free to speak, Your Honor?
You have a right to remain silent. Anything you choose to say about the facts or circumstances of this case, your statements can and will be used against you in the treatment of your case. You have an attorney. I highly recommend you speak with him privately. Otherwise, whatever you say can be heard, especially by our two prosecutors who are on the Zoom session.
I know, but I wanted
And
to.
Mr. Smith, at this time, I would encourage you to remain silent. I'm happy to have a conversation with your mother or speak with you privately outside of the presence of the court.
It's really stressful for me.
All right. And Miss Battle and Miss Bing, if you can get in touch with Miss Davis, she has the option of also seeking an ex parte TPO through the appropriate venue.
Yes, Your Honor.
All right. Its next court date is going to be June 9th. Thank you. Ms. Tracy Smith, do you have any questions?
No, ma'am. So it's $300 to bond him out today?
Through a bonding company. They typically charge between 10 to 15%, so the minimum would be $300.
Okay. All right. Thank you.
You'll need to report to pretrial once a week for a duration of 12 months.
Yes, Your Honor.
And where would that be at?
Fulton County, one of the offices at the Fulton County Court Complex.
What if he has no means of getting there? Because we live in Cumming.
Then he'll be in trouble.
He's not going to be able to get there unless he lives down there, and he does not. We live in Cumming. So
he'll need to make arrangements.
Okay.
Thank you. All right.
Thank you.
Glenn, thank you. Next case.
Next, we have position 10, Miss Fryer.
Oh, Mikkel Fryer, F-R-I-E-R. 1, 2. Okay, excuse me. Miss Fryer is accused under 26 CR 3347L. She has 5 misdemeanor charges against her in this accusation. They begin with battery, family violence, battery, simple battery, family violence, cruelty in the 3rd degree, and disorderly conduct.
Excuse me, I'm so sorry. Position 10, is that not Frank?
Mikkel Fryer. Frank is position 9.
Oh, I'm so sorry. Okay, sorry.
No, there may be a little out of order between the poll sheet and the
calendar.
Published calendar, yeah.
Okay, thank you. Sorry about that.
That's okay. So that's the 5 charges. Miss Harvey, do we have a GCIC on Miss Fryer?
Yes, Your Honor. 3 cycles. Last arrest was February 5th of 2017 out of Atlanta for driving on a suspended or canceled registration. Nothing further.
Okay. Miss Bing, was that your case?
Yes, it's my case. I was recommending a $2,500 surety bond. That's total. $2,500 total. Yes.
Okay. And since this is a family violence, do you have any conditions?
Yes. Stay away from the incident location. Stay away from the victim here. Believe it was Weems. Yes, Melvin Weems.
Mm-hmm.
That's W-E-E-M-A-M-S. No drugs or alcohol. Well, no drugs. No further violations of the law.
Okay. Mr. Coleman?
And no firearms. No firearms.
Got it. Thank you.
Yeah, I'd be requesting a signature bond for Ms. Fryer. She is 32 years of age. She has resided here in the Atlanta area for the last 15 years. She did attend some college. She's currently employed as an insurance agent for State Farm for the past 3 years. She is a mother of 3 children, ages 7 months, 7 years, and 10 years. As far as the stairway is concerned, I'd like the court to know that the lease in this case, for the apartment that Ms. Fryer resides in, that lease is in her name, not in the complaining witness's name, Mr. Weems. It looks like her last arrest was almost 10 years ago. Again, I'd be requesting a signature bond.
I'm trying to figure out whether Mr. Weems is the father of the children in question.
I believe he's the father of the 7-month-old.
Is that correct?
Yes, ma'am. But those charges are old.
How old?
Those charges were from 2020, I believe 2020, that I was never arrested for, and I took it to trial and got all those charges dropped because I was found not guilty. The charges that I'm here for are battery and cruelty to children.
You, Mikkel Freer, right?
Yes, ma'am.
Incident date is May 24th, 2026 at 12:40 a.m.
Yes.
and involves Melvin Weems at 3120 Oakley Place in Union City.
Yes, ma'am.
All these charges stem from that one incident.
Oh, they only gave me 2. That's fine.
There were warrants.
Sometimes the state will add additional charges.
Oh, okay. Thank you. I didn't.
Yeah. With regards to the allegations set forth over here, on the count 1, battery family violence, that's going to be a $2,000 bond. The remaining charges are going to be $1,000. So that's 1, 2, 3, 4, a $6,000 signature bond through pretrial services level 3. Which means that she reports to pretrial services once a week for a duration period of 12 months. During the 12 months of reporting to pretrial on her $6,000 signature bond, she will enroll and complete a domestic violence intervention program, and she will enroll in the program within 30 days of being released. This is a series of 24 weeks of classes that she would need to attend and complete at her expense. Failure to show proof of enrollment and attendance can be grounds to revoke her $6,000 surety bond. She's to have no further contact with Mr. Melvin Weems. I don't know where Mr. Melvin Weems is, so if he doesn't reside at the property any longer, she can return to the 3120 Oakley Place in Union City. But if he still resides at the property, then she is allowed to go there one time only to retrieve her belongings and her children, and then update us with a new address within 30 days. The police officer can verify whether Mr. Weems still resides at the property. Please remember, you have to stay 200 yards away from him and not communicate with him in any way, form, or manner. I'll allow for third-party transfer of any child or children that she shares with Mr. Weems. While this case is open and pending, Ms. Fryer, you are not allowed to consume any illegal drugs, including marijuana. You're not allowed to consume any alcoholic beverages and not allowed to own or possess any firearms. And just by coincidence, this is our second case today involving an umbrella. Must be the weather or something. Thank you. All right, next case.
Ma'am, Your Honor, you said surety? And
No, signature bond through pretrial level 3
Okay.
for 12 months. She reports for a duration of 12 months with the conditions that I've just listed.
Thank you, Your Honor.
Thank you.
Next, we got number 12, Mr. K.
This is state versus, I'm sorry, this was position 12, correct? Or was it
Yes, ma'am.
Skylar Brooke Gary?
No, Lee Gay.
Lee, okay. Lee Andrew Gay is a case 26 CR 3339C. And with regards to this case, there is a charge of terroristic threats and acts and disorderly conduct from May 23rd, 2026. You've been advised of your rights and your attorney is Is it Mr. Geddes or Mr. Coleman? I just didn't know. Mr.
It's me,
Geddes?
Your Honor.
Okay, thank you. All right, any prize, Ms. Harvey?
36 cycles. Last arrest was September 28th, 2022 out of Fulton County for aggravated assault, possession of a firearm during the commission of a crime, and possession of a firearm by a convicted felon. That does appear to be open under 24 SC 001879. There's a 2007 conviction for theft by shoplifting. Recommendation is a level 3 and nothing further.
All right. Miss Evans Battle? Oh, is it Miss Bing?
It's me,
Miss Bing.
Judge.
All right, yes.
It's for Gay, correct?
Gay, correct.
Okay, can you give me a moment? Because that's not the history that I had, so my recommendation is much different. So let me just verify what the information I have is for Lee Andrew Gay.
That would be correct. Warrant number ends with 2386. This is the incident involving Mary Carter.
Yes, Your Honor. All right. So, and that last arrest was, yes, Your Honor. In this particular case, we would be asking for a cash bond. We would be asking for a $5,000 cash bond on the terroristic threats and a $2,500 on the disorderly conduct. And so that would be a $7,500 cash bond. And consider in light of that 2022 case involved a weapon and that the defendant has indicated in his threat by the use of shooting the victim in this case, we'd ask that he stay away from the location. The location is 1415 Hawkins Street Northwest in Atlanta. No further contact with Mary Carter as well. No alcohol, drugs, any firearms in which he possessed. State would ask that they be surrendered. Thank you.
Mr. Geddes?
Thank you, Judge. So the initial paperwork that I received this morning suggested that he already had a surety bond of $1,630. So
that would be correct, yeah.
Yes. So obviously the court is unable to impose a bond that would be higher than that. I would ask the court to consider a reduction, considering that he's a lifelong resident of Georgia. He's expressed to me that the address where this took place is Rooming House. The alleged victim is a neighbor of his. He is on disability and receives Medicaid checks. So he is on a very fixed income. He has a back injury that prevents him from doing all sorts of different kind of employment positions. He would have some difficulty finding a new place to stay. So I would ask the court to consider not placing that stay away and to give him the lowest possible bond.
Okay. Ms. Harvey, can you confirm that that is the correct criminal history record for Mr. Gay, 36 arrest cycles with the recent open case for aggravated assault?
Yes, Your Honor, I did. That is the history that I'm showing. There are several aliases, several social security numbers, and date of birth associated with him on the GCIC.
The date of birth I have over here is September 1962. Would that be correct?
Correct. That's one of them on the GCIC, and the socials match what I have in Odyssey.
All right, thank you so much. Yes, with all due respect, Mr. Geddes, I believe, having done this for enough decades, when the electronic warrant judge issues a bond, I don't know if that judge has the benefit of the individual's criminal record history. So bonds are set simply based on the conversation that transpires between the testifying officer and the warrant judge. But now I have the benefit of his criminal history record. I do have the discretion to change the bond up, down, or the same. And in this particular case, on the terroristic threats, the bonds will be set at 2,000 surety. And on the disorderly conduct, it's going to be a UJR. No illegal drugs, no alcohol, no weapons. And he is to have no further contact with Mary Carter. He's also required to stay away from 1415 Hawkins Street in Atlanta, Georgia. Once he poses bond, he may return to the location one time only with a police officer. He's allowed to visit his unit in order to retrieve his belongings, but then he cannot stay in that building while this case is open and pending. He is not to consume any illegal drugs, no alcoholic beverages, and he's not allowed to own or possess any firearms. So when he goes to the building to retrieve his belongings, the only thing he cannot take with him is his firearm or any firearms. That would have to be surrendered to the police officer who escorts him to the building. Next court date is June 9th. Thank you.
So detective, you had 2 square 2s, is that correct?
That's correct.
Okay. Calling case prosecutor order number 26-21057. This is in the matter of, I'll spell R-R-O-A-K, last name M-I-T-A-J. Detective, would you raise your right hand and state your name, please?
Detective Meckel for the Royal Oak Police Department, Your Honor.
Okay, solemnly swear and affirm the testimony provided to the court is true and accurate?
I do.
Okay, please state the facts as you know them.
Again, Detective Meckel for the Royal Oak Police Department, Your Honor. Good morning. Today is a 3-count warrant charging Warrant Mataj with 3 counts of felony resistant obstruct causing injury to police officer. On May 24th, 2026, Royal Oak officers were dispatched to the area of 205 West 5th Avenue in the city of Royal Oak, where they were approached by a security staff member of the 5th Avenue bar requesting help for a patron that was fighting with staff. Officers observed 3 bouncers fighting with disorderly male, later identified as Warrant Mataj. Staff members attempted to escort Mataj out of the business when he became combative. Officers who were in full uniform and identified themselves as police arrested Mataj. Mataj was resisted and assaulted officers during the course of that arrest and transport to the patrol vehicle. Mataj pushed Officer Cole in the face, to which he later was treated in the emergency room for concussion. Mataj kicked Officer Plitz in the neck, to which he was later treated in the emergency room for swelling, bruising, and redness to his neck. Sergeant Paramount struggled to carry Mataj to the patrol vehicle while Mataj kicked and assaulted officers, causing Sergeant Paramount to fall. Sergeant Paramount was later treated in the emergency room for bruised shoulder contusion. I believe the information provided is specific. I'm sorry, Your Honor. I believe the information provided is sufficient to prove probable cause stand the alleged criminal offense was committed by named defendant. I have fixed my signature to the criminal complaint and respectfully request the court execute the warrant in this matter.
Okay, the court finds that the alleged crimes were committed, probable cause believed the defendant committed said offense. Court will sign and issue the complaint and warrant in these matters. Any additional CCH information that you may have?
I am actually pulling that. Bear with me. This was handled by
Okay, take your time.
This was handled by my partner yesterday, so I'm just reviewing it real quick to make sure.
Sure.
He is currently, it appears to be on probation out of the 16th Circuit.
All right. Anything else? I'm all set on what I have.
Yeah, he's got the CCH that you have is obviously he shows a decent criminal history. It looks like a lot of this has been deposed or reduced, but he is currently on probation. It's probably the only thing of major note.
Okay, thank you very much. Appreciate it.
Thank you, Your Honor.
I think he's in, I see the jail called in from your department, so I'm gonna bring in the attorney and put them in a breakout room. So thank you for your help.
Thank you.
All right. Calling case prosecutor order number 26-21057 in the matter of Ratak A. Mataj. Counsel appearance for the record, please.
Attorney.
And sir, yeah, I need whoever's on, I need to see whoever's face that is. Counsel appearance for the record.
Attorney Monica Sanford on behalf of Rock Mataj.
Okay, sir, at the jail, would you please state your full name for the record?
Rock, R-R-O-K, last name Mataj, M-I-T-A-J.
Okay, thank you for that, sir. Counsel, you may proceed.
Your Honor, I'd ask you to arraign him on the warrant. We would waive formal reading of the complaint and general information, and my client will stand mute.
Okay, the court will indicate that your client stands mute. Court-appointed counsel is granted in this file. And counsel, you can address bond.
Your Honor, my client is 25 years old. He graduated from the Henry Ford High School. He is currently unemployed. I understand that this is 3 counts of police officer assaulting, resisting, obstructing, causing injury. I would ask for a personal bond in this matter.
Okay. Thank you, counsel. It is three separate felony counts of resisting and obstructing. I think your client is currently on probation out of the 16th Circuit Court as well.
He denies that he is currently on probation.
Okay. Okay, before the court gets to bond in this matter, sir, I do have some conditions that I want to go over with you. I'll start with your next court date. You have a probable cause conference. These are three separate felony offenses. You have a probable cause conference scheduled for June the 1st of 2026 at 9:00 a.m. And then you have an exam scheduled after that for June the 8th at 9:00 a.m. This matter will be heard in the 44th District Court in Royal Oak. You will not have any direct or indirect contact with any employees of the Fifth Avenue Bar. You will not return to the premises of the Fifth Avenue Bar, which is located at 205 West Fifth Avenue in Royal Oak. You will not assault, beat, molest, or in any way verbally harass, intimidate, or threaten any witnesses in this matter. Personally appear for all your court appearances. Do not leave the state of Michigan without permission of this court. If you change your address or phone number, email, let the court know that. You will not possess any firearms or other dangerous weapons, and you shall refrain from using alcohol, any form of THC, marijuana, illegal drugs, or abusing any medication. Pick up no new criminal offenses while you're out on bond. You will be supervised, and you must contact pretrial services within 24 hours of your release. The court has temporarily granted court-appointed attorney for you, so you will have an attorney representing you at your next court date. Do you understand your bond conditions, sir?
Yes.
Okay. Well, as I indicated, these are three separate assaultive matters. Whether you're currently on probation, my information is that you are at the 16th Circuit, but these are three separate assault cases. That does give the court some concern. And then there was the incident at the allegations at the Fifth Avenue location as well.
Those were all at the same place.
I understand.
Yep.
I don't want you to say too much, so I'm just trying to hold off on that. But that does give the court some concern at this particular time as to general safety of parties involved in this matter. The court's going to set bond in the amount of $8,000 cash surety, no 10% in this file. And we will see you at your next court date, sir. So best of luck to you.
Is this a
It's an
I'm sorry, I didn't
$8,000 cash surety, no 10%. It is not a personal bond. That means you have to get a bail's bondsman to post for the $8,000.
Okay. And so in that case, I gotta wait till my court date?
Yes, you will have to wait till your court date, which is June 1st.
All right. That it?
Yep, that's it.
That's it.
You can hand the iPad over. Thank you.
Calling case Robert Knorr, 2615645 in the matter of Anaway Blue Jay Deer and Water. Detective, you still under oath. Just state your name in this file.
Detective Mecco for the Road Police Department, Your Honor.
Okay. Yeah. Please state the facts as you know them.
Before you today, Your Honor, is a one-count warrant charging Anahuac Blue Jay Deer and Water with domestic violence, simple assault. The facts of the case are documented in Royal Oak Police Report number 26-15645 and are summarized as follows. On 5/25/26, our OPD officers were dispatched to 811 East 11 Mile Road in the city of Royal Oak, County of Oakland, state of Michigan. Officers were dispatched for a possible domestic assault that occurred in room 110. Officers arrived on scene and immediately observed a female, later identified as Deer and Water, yelling and walking through the parking lot towards 11 Mile Road. They observed a male, later identified as Morris, in the parking lot as well. Officers separated the parties and learned that Deer and Water was intoxicated and that the party had been staying in the motel for the night. Deer and Water became upset with him and attempted to leave. Morris attempted to keep her in the hotel room due to her intoxication, only wearing a nightgown. Upon attempting to stop her from leaving, she began to hit him in the face and pull his hair. Officer spoke with Deer and Water, and she informed that she was intoxicated and that she wanted to get some fresh air. She stated that she was upset and struck him several times and bit him when he attempted to keep her from leaving. Deer and Water was placed on arrest for domestic violence assault. I believe the information provided is sufficient to prove probable cause standard. The alleged criminal offense was committed by any defendant. I fixed my signature to the criminal complaint in respect to the request the court execute the warrant in this matter.
The court finds that the alleged crime was committed, probable cause to believe the defendant committed said offense. Court will sign and issue the complaint and warrant in this matter. Anything additional you want the court to be aware of, CCH information or anything else?
No, Your Honor, she had no CCH that I was able to locate.
Okay. All right. So let me, one question on the, I think that the other matter, the my job matter, you indicated that was that at the 205 West 5th Avenue in Rollo location?
That is correct. That is correct.
What is the name of that business?
It's 5th Avenue Bar.
Okay. Got it. I'm all set then. Thank you very much.
Thank you, Your Honor. I appreciate it.
Okay. A calling case Robert Nora 2615645 in the matter of Anna Wake Blue Jay Deeringwater. Counsel appearance in this matter, please.
Attorney Monica Sanford on behalf of Anna Wake Deeringwater.
Okay, ma'am, would you please state your name for the record?
Anna Wake Deeringwater.
Okay, thank you, counsel. You may proceed.
Yes, Your Honor, I would ask for the warrant for the complaint to be set aside. We would waive formal reading of that complaint, and my client will stand mute at this time.
Court will indicate that your client stands mute. The court-appointed counsel is also granted in this file. Counsel, you can address bond.
My client is 20 years old. She did graduate. She was homeschooled, but she did graduate from high school. She is currently babysitting for her aunt. I would ask for a personal bond in this matter.
Thank you. So before the court gets to bond Deeringwater, the court's going to go over a few bond conditions with you. You will not have any direct or indirect contact with the complaining witness in this matter, Damon Morse. Is that going to be a problem for you?
You can say no or yes, okay?
That won't be a problem.
Okay, that means no phone calls, no emails, no text messages, no third-party contact whatsoever. You will not go to or return to his residence, place of employment. You will not assault, beat, molest, or in any way verbally harass, intimidate, or threaten any witnesses in this matter. Personally appear for all your court appearances. Do not leave the state of Michigan without permission of this court. If you change your address, phone number, email, let the court know that as well. You will not, shall not possess any firearms or other dangerous weapons. Alcohol may have been a factor in this matter. The court is going to require that you refrain from using alcohol, any form of THC, marijuana, illegal drugs, or abusing any medication. You will be required to test 2 times a week for alcohol and drugs, and you must contact pretrial services within 24 hours of your release. Pick up no new criminal offenses while you're out on bond. This matter will be set for a pretrial. It's going to be at the 44th District Court in Royal Oak. So far, do you understand your bond conditions?
Yes, sir.
Okay. I'm going to set bond in the amount of $1,000. Personal recognizance bond in this file. We'll see you at your next court date. Do not violate the court's conditions, okay? Okay, all right, you're all set. Good luck to you. So, Detective, are you here on the Montgomery matter?
I am, Your Honor.
Okay. Calling case prosecutor order number 26-21050 in the matter of David Lee Montgomery. Detective, would you raise your right hand and state your name for the record, please?
Detective Cody Johnson.
Okay, solemnly swear and affirm the testimony you provide to the court this morning is true and accurate?
I do.
Okay, please state the facts as you know them, Detective.
Deputies were dispatched to 148 Mark Avenue. The caller stated that he had just shot his wife. On deputies' arrival, they took David Montgomery into custody. Deputies then located Jacqueline Montgomery inside the residence. She had a gunshot wound to the right side of her face. She was transported to McLaren Hospital to receive treatment. David Montgomery was then transported to the Oakland County Jail. There he was interviewed. David stated to deputies that he'd been experiencing marital issues and stated that he had been fantasizing or thinking about shooting his wife lately. He stated that on the night of the incident, he confronted her wife about infidelity. This led to a brief argument, at which point David pulled a pistol out, aimed at her head, and fired. The round struck her on the right side of her face near her neck and jaw. After he shot her, David then stated that he did call 911 to report that he had shot his wife. David was transported to Oakland County Jail without incident. Nothing further.
Court finds that the alleged crimes were committed, probable cause believed defendant committed said offense. Court will sign and issue the complaint and warrant in this matter. Anything further, Detective?
No, just I would recommend no bond, obviously, due to him pre-planning this and having access to all the residence where she's gonna be.
Okay, thank you very much, Detective. Have a good
Thank
day.
you. You have a good weekend.
All right. Yep. Yeah, 2000. At the jail, what is your last name?
This is David Montgomery.
Okay, thank you. Okay, calling case prosecuting order number 26-21050. This is a matter of David Lee Montgomery. Counsel appearance for the record, please.
Attorney Monica Sanford on behalf of David Lee Montgomery.
Mr. Montgomery, would you state your full name for the record, sir?
David Lee Montgomery.
Okay, thank you very much. Counsel, you may proceed.
Your Honor, I would waive formal reading of the complaint and general information, and my client will stand mute.
The court will indicate that your client stands mute. The court will grant court-appointed counsel, at least for the arraignment, until we can get some additional information on Mr. Montgomery. Court-appointed counsel has been granted in this file. Counsel, would you like to address bond in this matter?
Yes, I do understand the seriousness of this matter. My client is 70 years old. He receives Social Security, SSI benefits. He has a master's degree. He has 2 businesses. He owns Mark Avenue Enterprise, LLC. He's a realtor, and he's owned this business since 2018. He's also a tax preparer. His business name is MSF, and he's been doing taxes since 1980. My client does have some mental and physical health concerns. While I do understand the seriousness of this matter, it is my understanding that he would not return to the residence, and that he could be able to reside with his daughter, who was interviewed, Miss Ashley Jennings. He has 3 adult children, and for the past 18 years, he did live at the family address. This is a very unfortunate circumstance. Prior to this, I don't see that he had any prior major convictions from prior to this occurrence. And so while I understand the seriousness of the matter, and I do understand that there needs to be some type of financial bond, I would ask for some leniency with how high that financial bond is.
Okay, thank you for that, counsel. So before the court gets to bond, Mr. Montgomery, I want to advise you of your next court dates. This is a serious felony matter. Carries up to possibility of life incarceration. But your next court dates that are going to be coming up, and you'll get a copy of everything I'm going over with you. Your next court date is your probable cause conference. It's scheduled for 1:30 p.m. on June the 2nd of 2026 at the 50th District Court. And you have an exam scheduled after that for June the 9th of 2026 at 9:00 a.m. The other conditions are you will not have any direct or indirect contact with the complaining witness in this matter. Jacqueline Montgomery, I believe is your wife. You will not return to the premises of 148 Mark Avenue in Pontiac, Michigan. You will not assault, beat, molest, or in any way verbally harass, intimidate, or threaten any witnesses in this matter. Personally appear for all your court appearances, sir. Do not leave the state of Michigan without permission of this court. Immediately notify the court in writing if you should change your address or phone number. You need to provide the court with a valid release address within 24 hours of being released. You will not possess any firearms or other dangerous weapons, and you shall refrain from using alcohol, any form of THC, marijuana, illegal drugs, or abusing any medication. You must contact pretrial services within 24 hours of being released. That's at the 50th District Court in Pontiac. Pick up no new criminal offenses while you're out on bond. As indicated, court-appointed counsel has been granted at this stage in the proceedings. So with that being said, sir, do you understand your bond conditions that I've read off?
Yes.
Okay. The allegations I indicated are of a very serious nature. It carries up to life, possibility of any term of years up to life incarceration on one of the counts. The court has some serious concern for the safety of the complaining witness in this matter, as well as the general public and your ability to return to court based upon the seriousness of the crime. The court will deny bond in this matter. There will be no bond. So you're all set, sir. The door behind you is open and you can walk out.
Thank you.
Okay, calling case 26-001365. This is in the matter of Jada Campbell. Counsel appearance for the record, please.
Good morning, Attorney Monica Sanford on behalf of Jada Campbell.
Ms. Campbell, would you state your name for the record?
Jada Raymore Campbell.
Okay, thank you. And counsel, you may proceed.
Your Honor, I asked for the warrant to be set aside. I would waive from a reading of the complaint and my client will stay on mute.
The court will indicate that your client stands mute. Recall the bench warrant in this matter. Court-appointed counsel is requested and granted in this matter. Also, Ms. Campbell, state your full name for the record, please.
Jada Lachey Raymore Campbell.
Okay, thank you. And counsel, you can address bond.
Yes, I do want to address the fact that on the complaint, it has an apartment number. She lives at a house, so there is no apartment number. I don't know where that came from. I would just note for the record, my client is 25 years old. She graduated from high school at the Jalen Rose Leadership Academy. She attended Ferris State, although she did not complete. She is currently employed at Angel's Place, which is an adult foster home in Commerce. I do not believe that she's a flight risk, and I do believe that she will attend all further court proceedings. I'd ask for this, for Ms. Campbell to be given a personal bond at this time.
Thank you, counsel. So is she at the Grand River? She's not at the Grand River location in Farmington Hills, or not?
No, the 19802 Freeland Street is her address. It's just that it says apartment 2103, which there is no apartment. That must be Farmington maybe, but she doesn't live there. Her boyfriend does.
Okay, I'm gonna get the address. I didn't even, that information on the documents that I have are actually different. Did you say so is she at you said she's at the Freeland Street location?
Yes, 19802 Freeland Street, Detroit.
Yep, I have that. Okay, it's just listed differently on the other documents. Thank you, counsel. Officer, are you there at the jail as well?
Yes, Your Honor.
Okay, I'm just looking over some matters here. It looked like there was an incident in Roseville in 2024, and then some kind of assaultive matter that involved 18 months probation in 2024 out of the 52-1. Do you have anything you want to add or any CCH information you wanted to provide the court with?
It looks like she had some domestic violence, but they were all dismissed. One was in a as well.
Okay, thank you. Ms. Campbell, I guess I just want to ask you, the court just has some concern as it relates to whether or not you're going to attempt to contact any of the parties that I mentioned. If I give you some bond conditions and tell you to stay away from certain places and individuals, can you abide by that? Can you do that?
Yes.
Okay. Court's going to set bond in the amount of 1,000 personal recognizance bond in this file. Ma'am, I do have those conditions. You're not to have any direct or indirect contact with the complaining witness in this matter. Marzell Woods, you will not return to the premises known as 47723 Fernwood Apartment 15208 in Wixom, Michigan. You will not assault, beat, molest, in any way, verbally harass, intimidate, or threaten any witnesses in this matter. Personally appear for all your court proceedings. Do not leave the state of Michigan without permission of this court. If you change your address, phone number, email, let the court know that as well. You will not possess any firearms or other dangerous weapons. You must contact the 52-1 Bond Compliance Unit at the Novi District Court. If you're released, pick up no new criminal offenses while you're out on bond. This matter will be set for a pretrial, your next court date. You'll get a copy of what I'm going over with you before you get released. Other than that, ma'am, your next pretrial date, and as I've indicated, you will have an attorney representing you at that appearance. Do you understand your bond conditions?
Yes.
Okay, anything further, counsel?
Nothing further.
Okay, all right, ma'am, good luck to you. Just make sure you follow the conditions, okay?
Okay, thank you.
All right.
Right, you're outside. Ready? Do you want to make some phone calls?
Yeah.
All right, let's do that.
It's my 500.
Detective, which case are you here on?
I'm going to be here on Isaac Hernandez, as well as Barry Hunt.
Okay, Hernandez and Hunt?
Correct.
Okay, thank you. Calling case prosecutor order number 26-21070 in the matter of Isaac Hernandez. Detective, would you raise your right hand and state your name, please?
Detective Michael Hennigy, Oakland County Sheriff's Office.
Okay, you solemnly swear and affirm the testimony you provide to the court this morning is true and accurate?
Yes, sir.
Okay, please state the facts as you know them, Detective, in the Hernandez matter.
On 5/24/2026, deputies were dispatched to 85 West Ruck, local state of Michigan, for possible domestic violence call. On-scene deputies spoke to the victim, Jasleen Hernandez, who stated she wanted to confront her brother, Isaac Hernandez, who lives with her, about a damaged windshield that she had on the car she was driving. She advised that when she confronted Isaac, the two began to argue. Jasleen stated that she grabbed her bag and her keys and tried to leave the residence. Jasleen stated that Isaac would not let her leave the house. She advised Isaac grabbed her bag and tried to take it from her. Jasleen stated that the strap on her bag broke and she fell to the floor. Jasleen stated that Isaac then kicked her in the stomach while she was on the ground. A later interview between deputies and Isaac admitted that he kicked Jasleen and stated that it was a gentle kick. Isaac was subsequently arrested, lodged at Oakland County Jail. Oakland County Prosecutor's Office reviewed this case, wrote a 1-count warrant for domestic assault.
The court finds that the alleged crime was committed, probable cause believed the defendant committed said offense. Court will sign and issue the complaint warrant in this matter. Any additional information you want the court to be aware of before the arraignment?
No, sir.
Okay, thank you. Okay, calling case prosecutor order number 26-21070 in the matter of Isaac Hernandez. Counsel appearance for the record, please.
Tony Monica Sanford on behalf of Isaac Hernandez.
Ms. Hernandez, would you state your name?
Isaac Hernandez.
Okay, thank you. Counsel, you may proceed.
Your Honor, I'd ask you would arraign him on the warrant, waive formal reading of the warrant and complaint, and my client stands mute.
The court will indicate that your client stands mute in this matter. Court-appointed counsel is also granted. Counsel, you can address bond.
Your Honor, my client is 19 years old. This is alleged that this incident occurred with his sister. He is not currently employed. He does have a friend that he can go and reside with. He would need to provide that address on tomorrow, the next business day, if he were to be granted a personal bond. He understands that he cannot return to the residence. I would ask for a one-time police escort so that he could get his belongings, and I do believe a personal bond would be appropriate.
Okay, thank you, Counselor. I recognize the defendant's age in this matter. There appears to be some issues that may have occurred even a little earlier in his travels. So before the court gets to bond, I do have some conditions, sir. State your full name again.
Isaac Luciel Hernandez.
You will not have any direct or indirect contact with the complaining witness in this matter. Jasleen Hernandez, no contact with her, that person. You will not return to the premises of 85 West Rutgers Avenue in Pontiac. You will be allowed to go back there one time and one time only, and only with a police escort to obtain minor personal items that you may have left there. But you have to make those arrangements with the police department. You cannot go back there by yourself. You will not assault, beat, molest, or in any way verbally harass or threaten any witnesses. Personally appear for all your court appearances. Do not leave the state of Michigan without permission of this court. If you change your address, phone number, email, let the court know that. You shall not possess any firearms or other dangerous weapons, and you shall refrain from using alcohol, any form of THC, marijuana, illegal drugs, or abusing any medication. You must contact pretrial services within 24 hours of your release. Pick up no new criminal offenses, sir, while you're out on bond. And as counsel has indicated, you need to provide the court with a valid release address within 24 hours of being released from custody. Court-appointed counsel has been granted for you. As indicated, your next court date is a pretrial date. And you'll get that date in the mail. But just to make sure you don't miss your court date, you might want to contact the court sometime in the middle of this week, Thursday or Friday, just to get your court date, because you have to find a place to live really, really soon. We will make sure you get your mail. Do you understand your bond conditions so far?
Yes.
Okay. And based upon the allegations of an assault of nature, I do have some concern for the alleged victim in this matter. Court's going to set bond amount of $500 cash surety, no 10%. So you're all set, sir. Just walk out the back. The door is open. Good luck to you.
Thank you.
I mean, we're having all these conversations in chat, and I'm not paying attention to it. It's the end of the show. Oh my God, it's Monday night. It's a new week, ladies and gentlemen. It is Memorial Day. It's been Memorial Day all day long. Thank you to our fallen heroes and all of our friends who have served out there. Rhonda, looking at you. Papa Wolfie, looking at you. Ladies and gentlemen, thank you all very much for hanging out with me today on this very special. Oh, Dobby, Flow State, Jamergerger, thank you so very much for your donation. All you crazy people who've been donating sparkles and jewels and flowers and flow states and stuff that I don't even understand. Thank you so very much. It's amazing. All you crazy people. Def Leopard, Mary Beth, Wendy Greek, Dobby, Natasha Kitty, Marty Duvall, Gobby, Felix. I'm sure there's more. There's more here. There's a lot of Def Leopard. A lot of Marty. There's a lot of Natasha. Thank you all. Thank you all for the contributions. It is through interactions with viewers like you that this channel can do what it do, ladies and gentlemen. And because it was a Memorial Day, we started things off with a few things from last week that I thought were interesting that I just had not had a chance to get to yet. And then I threw in some first appearances that actually happened today, because a lot of people were missing some of that type of stuff. And I do know that my good friend Northwest out there really liked seeing the swear-tos along with the warrant arraignments. So I was happy I could throw that together for us for a very special Memorial Day show. We got more court coming tomorrow, regular court all day long. So make sure you're tuned in and make sure you're like subscribed, you're commenting, and you're interacting. Hey, look at this. We have a scroll of names happening on the screen right here. There's a lot more supporters than just Jamerger. We got all these: Rhonda, Ann, Felix, Julie, Donald, Mama, Romiticus, North, Jen. What did I don't know what's happening anymore. Oh, I do know. So somehow it knows who the regulars are, I guess. I don't know. This is all crazy. It's new to me. All you people, Katie's name is in there. Mr. Beep's name is in there. Let go of the rope. Bat Boy is back. Big Tiff Dog looking at you. Charlene Tut. Courtroom Files. How you doing? Mortimer Duke. Great to see you again. Lone Wolf Bot. Why are you here? Really? Nobody likes you. Really? You do a good job. Nobody likes you. They really don't. Lone Wolf Bot will be back in business tomorrow probably, so keep an eye out over there if you're looking for just some courtroom archive play. We'll be messing around with some of my algorithm stuff, so I'll be generating some court videos and throwing some stuff on up there. So get to watching some court content, ladies and gentlemen. It has been a pleasure bringing you what I had for you today, and I hope to see you tomorrow. Same wolf time, same wolf channel. I am out. That was really kind of cheesy. Yeah, I'm out. Wait. It's like you expect me to come back and actually do. Oh, hey, Miss Natasha Kitty just sent another gift. Thank you so much. I really appreciate that. I got nothing else now. I don't know why you're still here. I'm not going to mention Ferris Bueller's Day. Oh, that I go. Do I do it? Yeah. Peace out. Bye.